Nope, don't give me attitude. All right. And I guess when I order people to do things, they're like, you know what? Let me just come before the judge and say, I wasn't able to do it. In this case, the person I have before me, this is his first motion to revoke, and it's for drinking alcohol, which he's not allowed to drink alcohol. I know I ordered sober support meetings, and that wasn't done. And I do know that I tell everybody, if there's an issue, you can come back to court and address it with me. All right, then we'll proceed on this. All right, the court is calling 2023 CR 8639W, State of Texas versus Stephen Carmona. Could I have the parties announced for the record for the state? Defense.
And Johnny Cisneros.
And are you Mr. Carmona?
Yes, Your Honor.
All right, is your name Stephen?
No, it's Stephen Samuel.
Okay, I don't, on the motion to revoke and all the paperwork, it says Stephen.
I think that's because the way the DPS issued my license, they put Stephen.
Ah, so your license is Stephen.
Yeah.
Ah, okay.
I've called and tried to get a new one, but.
All right. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney?
Yes,
Did you understand it?
I did.
Are you the same Stephen Carmona who was placed on deferred adjudication in 2023 CR 8639W for the offense of repeated violation court order bond condition on October 3rd, 2023 for a period of 6 years? Is that you?
Yes, Your Honor.
All right, state.
Yes, Your Honor. Violating condition number 2 on or about the 5th day of October 2023. Deferred County, Texas. Defendant Stephen Carmona is in there concerning alcoholic beverages violation condition number 2.
How do you plead to that? True or not true?
True, Your Honor.
All right. Excuse me, can I have a stamp for a motion to revoke? All right, thank you. And state with regards to the other violation? Any objection?
No objections, Your Honor.
Okay. Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine?
I do, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 2?
Your Honor.
Court will find violation of condition number 2 true. Is there a proposed agreement?
No, there's not, Your Honor.
All right, state, what are you recommending? All right. And defense?
Judge, I'm recommending that you continue him on probation. He's been doing good. He's been on the GPS for 11 months approximately. And he hasn't had any violations. It's in the actual report that there's no violations. There haven't been any violations. And other than drinking alcohol that day, he's been doing wonderful. He's doing good. He's been following my advice. He's been following the court's advice or orders. And he's doing great, except for that one mistake, bad decision, not a mistake, bad decision. And I'd like for him to just continue him on probation and let's keep seeing how he continues. And if he continues to do well, then he'll be successful.
All right, so last time we were here in July, the warrant was recalled. And I asked that he complete daily sober meetings. Has that been done?
No, Your Honor. I recently have.
Let me have you raise your right hand for me.
Oh.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Stephen Carmona.
All right, so I ordered daily sober meetings. Why hasn't that been done?
I recently got an employment as a director of operations in a call center. It gives me 7 to 7 hours, Monday to Friday. I also have a 5-year-old that I share like joint custody with. So I have him anytime his mom is at work. She works in the evenings. So she goes in anytime between 7 p.m. and 9 p.m. So because of that, I couldn't find any virtual AA meeting. And the only ones that I could attend would start at 10 o'clock.
All right, so did you come into the court and tell me or tell your probation officer, hey, I know the judge ordered daily sober support meetings, but here's the issue I'm having?
I did tell my probation officer this past time that I saw Ms. Guerra, and she did tell me that I could go online for resources, and she provided me a link and information so I could go and start attending it. This was this past week.
All right, so I had ordered that since July 11th. Why are you only doing it this past week?
So initially, when I did talk to my probation officer, Ms. Guerra, she had told me not to report because of the fact that the systems were still showing an active warrant. So the last time I was in here, I was detained. I thought it was for failure to appear here, but it was, she told me that it was failure to report, which I wasn't aware of. And when she did call me and tell me, that's when I went and reported, and that's when I gave her all the information.
All right, any other questions?
Other question.
Ms. Abrams? So has he spoken to his probation officer about the sober support meetings?
I was just reviewing, the notes on the case.
Your Honor, if I may,
Yes.
I would like for you to continue him. And I will promise you, I will have a very stern conversation with him about following the court's orders. I know it's July and then August, so we're missing a few days here that he didn't do what he was ordered to do. But I will have a very stern conversation with him. I will tell him, as he already knows, the possible results of what can happen if he doesn't follow the court's orders. But I've gotten to know Mr. Carmona since he retained me. He is a fine young man. He has been doing well with the orders other than the alcohol consumption and this. So if I may get in a little bit of an extension for him so he can start doing what he needs to do. And then we're due back in January. So on the other case, and we can come on that day or we can come anytime in between there, Your Honor.
All right. Ms. Abrams?
Yes, Judge, I did review the notes that were in the system and no notes indicate that conversation was had in regards to sober support.
All right. So let me ask you this. Is it possible to have his probation officer zoom in?
Judge, the probation officer listed is on modified duty. I can make sure, due to health reasons, I can
Okay.
make sure she's in the office and see if she can.
All right, then if she can't zoom in today, I can recall that.
I've been working with, and I advised him to Google virtual alcohol meetings. It was on the exit as I was leaving probation. I wouldn't come up here and put myself at the mercy of the court, trying to claim some ownership for what I've done. I understand that it's wrong, right? I do. I fully take responsibility for that. My thing is that, you know, like I was telling Mr. Cisneros, is on paper, it might look like I make money, but I got a mortgage, I got child support, I got utilities, I got other fees like GPS and probation and bondsmen. And so when it's all said and done with, I'm limited. You know, I got my 5-year-old that I take care of half the time, so his mom can go to work in the evenings. I mean, there's a lot of things that I'm doing, you know, and that's where I ask for you, please, to reinstate my probation. And, you know, it's one of those things where I've gone through a whole bunch of stuff. My divorce after 18 months was finalized in July. Just a whole bunch of stuff that's been going on. And
All right, any questions, State?
Oh,
All right, so Ms. Abrams, in state, in the defense. So in this case, the person I have before me, this is his first motion to revoke, and it's for drinking alcohol, which he's not allowed to drink alcohol. I know I ordered sober support meetings, and that wasn't done. And I do know that I tell everybody, if there's an issue, you can come back to court and address it with me. And I guess when I order people to do things, they're like, you know what, let me just come before the judge and say, I wasn't able to do it. Instead of coming in, nope, don't give me attitude. All right. Instead of coming in and saying, I have an issue with sober support meetings. This is what's going on in my life. Then that could have been something that perhaps we could have figured out. But when people are doing their own things and then come to me at the end of the day trying to figure something out, something should have been figured out in July.
I agree.
Your Honor,
I don't mean no disrespect at all, you know, and it was maybe something that I just didn't know. I mean, I have called up here to the courts and I talked to, you know,
No, I tell people to come in.
yeah.
Do I not tell people that they can come into court?
I
Just one
understand.
second, Miss Abrams, there's something you wanted to say?
Oh, no, Judge.
Okay. All right, so
Judge,
then,
if I may say one more thing.
yes,
And excuse me for interrupting. The probation officer opened the door about there being a possibility that he did talk to her about it, because she said, not that I can recall. So I'm believing my client that he did talk to her about it. And of course, there's still the he said, she said situation, but she herself, and I'm gonna repeat myself, but she said that not that I can recall. So I think, again, if I may re-urge my request of the court to just give him another chance, I'll have a very strong and stern meeting with him and conversation and tell him that it's, while we understand it's a zero tolerance policy now, I will make sure and reassure that he knows what zero policy means and we can put him on or zero tolerance. So I'm asking for one more chance for him. I've gotten to know him, like I mentioned. He's a wonderful young man, just didn't follow the court's orders, and I don't think he understood the gravity of the situation. And we're just asking for a continuance, Your Honor.
anything else from the state?
No,
All right. Anything else from probation?
Judge, I would like to point out that, Mr. Carmona has completed his parenting classes, which gave him full credit for his community service hours. He has given 3 negative UAs. He is, paying toward his fees, being on GPS. He's not received any other violations.
Okay.
So just those points to give the court to consider.
So what he has done as a violation of his probation, he was placed on probation October 3rd, 2023. And this is his first violation, and it's drinking alcohol.
that's correct.
All right. You are not allowed to drink alcohol while you're on probation, period. Doesn't matter if you're in your house, doesn't matter that alcohol is legal. Those are the rules that the legislature set up. It is not my rule per se. It's the legislature's rule. You're not allowed to drink alcohol. Do you understand? All right. I'm going to continue him because this is his first motion to revoke and it's for drinking alcohol. I'm not removing GPS. That's going to be a punishment.
Yeah, understood.
So he's going to have GPS for 60 more days. Do you understand?
Yes, ma'am.
Is there anything you do not understand?
No, ma'am.
And I want those sober support meetings, and you're going to do sober support meetings 60 and 60 days. Do you understand?
Yes, ma'am.
Is there anything you do not understand?
No, ma'am.
And for the last time, this is what I'm going to say. If there's an issue, let your probation officer know. If you feel as though they're not addressing it, you can walk into this courtroom. Do you understand?
I do. Yes, ma'am.
All right, thank you.
Thank you.
Yes.
See, I apologize. During his last TAP evaluation, it was, based on the information that was provided, substance abuse treatment was not recommended at that point.
Mhm.
I would like to see about getting another TAP recommendation completed based on the offense that was, the drinking alcohol, and then maybe a little bit of his previous, criminal history.
All right, so it's going to be deny the motion, alter the main conditions to include a TAP evaluation, out of custody, follow TAP recommendations. If TAP recommends inpatient, we'll start with outpatient treatment. There's going to be 60 sober meetings in 60 days and 60 days GPS.
Your Honor, would the court be open to an oral motion for the waiver of the fees of the GPS?
The only thing is I can ask that they be deferred and waived, but that's a third-party contract.
Okay. Thank you, Your Honor.
All right, is there anything else?
No, Your Honor.
Not,
W, State of Texas versus Jesus Pettis. Can our parties announce for the record for the state?
Daniel, as support for the state.
Defense?
Anita Pettis for the defense, Judge.
Are you Mr. Pettis?
Yes, ma'am.
Did you review the motion to revoke community supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Jesus Pettis who was placed on community supervision in 2022 CR 3531W for the offense of possession of a controlled substance penalty group 1,
Yes, ma'am.
1 gram to 4 grams? All right, is there any motion or a motion to add to the allegation, I'm sorry, to add that Mr. Pettis is on probation for possession of controlled substance penalty group 1, 1 gram to 4 grams in the motion to revoke?
Yes, Judge David made more motion to add the 1 to 4 grams.
Any objection?
I don't know what's going on. Oh, okay, got it. Yeah, that's fine. No objection, Judge.
All right. So are you the same Jesus Pettis who was placed on community supervision in 2022 3531W for the offense of possession of controlled substance penalty group 1, 1 grams to 4 grams on April 12, 2022 for a period of 6 years? Is that you?
Yes, ma'am.
State?
Violated condition number 4 in Bear County, Texas, defendant Jesus Pettis did then and there fail to report to the supervision officer as directed for the months of January and February 2024 in violation of condition number 4.
How do you plead to that? True or not true?
Judge State waived all the violations.
Any objections?
No objection.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, sentence you to $1,000 fine and 6 years in the prison? Knowing that, do you still wish to plead true to violation of condition number 4? You need to speak up.
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, Judge, the proposed agreement is to deny the motion, alternative to include ISP and referral for the drug court long custody.
All right, so here's the court's question. He hasn't been seen since January. Where has he been?
I defer to my client, Mr. Pettis.
All right, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, if you can state your name for the record.
Jesus Pettis.
All right, where have you been?
I have been working vending as a vendor in the Mexican restaurants selling palm leaf crosses. I make the crosses out of palm leaves and the leaves. And that's what I've been doing, just minding my business, going to work and staying with my friend Irene in her house, and I've just been staying back and forth at the address that I gave you for probation. And that's what I've been doing. I've been staying clean, sober.
Well, we don't know if you've been clean or sober
Of course,
because you
I
haven't been reporting.
Yes, of course.
So I
we'll
don't
have to
believe that.
assume- Yeah, you would have to assume the worst, of course.
No, it's not an assumption of the worst. Part of people, if you're in your sobriety, then you follow through on your commitments.
Correct.
You didn't report, so I know you were probably still using. That's why you didn't report.
Yeah, just if I may. So my client was supposed to report as part of a DDRF MIC program. I think my client obviously is someone with a diagnosable mental illness. He does have diagnosis for bipolar and what else did you say?
Oh, and major depression,
And
schizoaffective.
schizoaffective disorder, Your Honor. I know that he made some attempts and he did not have a phone. I don't know if the court,
But didn't he have a car?
no, Judge.
Well, how did he get to his work? Was his employment outside his house?
Yeah,
Walking
he just
bus.
walks, Judge.
Wait a minute,
There is
he
a
said
witness.
walked in bus. Then why can you take a bus to your probation officer?
With excuses.
Okay. Yes.
Yes, Judge. And with respects to our witness, Irene, I've made several attempts to contact her and I have not been successful. Otherwise, I would want some further testimony for the court. All I can say is that I don't know if he would be a good probationer. Mr. Pettis has never been to prison before. He has obviously, I don't know if the court has the report from the PSI. He's only had some misdemeanors. This is obviously, it will be his first felony, so I would hope that the court would follow our agreement and our understanding that he should be given 2 years to do, Judge.
All right, so here's your choice. Sometimes I can give people choices, sometimes I cannot. Do I think you need inpatient treatment? I'm sorry. All right. Do I think you need inpatient treatment? Yes. And probation, did they confer with you?
Yeah, that's why I'm a little confused, but
Right, because, and,
that wasn't.
right, I understand. And
All right,
that-
so stop. We're on the record.
Sorry.
So, probation, what were you saying?
I thought that we had agreed, there was some miscommunication, Judge. So, when defense and I spoke, she asked that, if I agreed to the revocation,
That's correct.
and
Judge.
we did agree. But I think it was miscommunication with defense and state.
Right, Your Honor, because I think originally that's asked if I would follow this recommendation. That's where I asked her to speak on Sean.
Okay.
And I think that might have been the miscommunications there.
All right, so this is what the court will do. I'm going to give you a choice. Right? You can either do 4 years in the prison, or you're going into inpatient treatment, and it's not ISF. So I can either, well, I will refer you to SafeP if felony drug court does not accept you, or you can do 4 years in the prison.
What do you want to do? I mean, I don't know how long safety is for.
He's 6 months and then 3 months aftercare. And that's inpatient.
Will I continue, will I still be on probation?
Yes,
And then the 4 years,
or either 4 years prison and you're not on probation. You're going to go to prison for 4 years.
Judge, I don't think that's fair. I mean, I think.
I'm
think
giving
that-
him a choice.
I understand, Judge.
So
I mean,
what's,
he's-
what's
but
not
he's a
fair is
first-time offender, you know,
he's on regular probation. He already has a felony conviction. I'm giving him a choice. He can either do 4 years in the prison, or either he can do inpatient treatment. Those are his choices. I don't know what is not fair about me giving him a choice. Inpatient treatment, which is what they're recommending, or 4 years in the prison. Those are his choices. Like, that's what you all came up and agreed to with me. You said, we agree ISF. That's inpatient.
and that wasn't our agreement, Daniel. I mean, we talked about the time. We talked about a time offer, and I asked Rashawn if she was fine with that, and she said she was fine with that, so I don't know why.
And again, my understanding, I just remember asking to pay with the recommendation. I asked if Sean agreed with that. That was what I asked.
This judge just put 2 futures on the table. Jesus Pettis vanished from probation, skipped reporting, and now claims he was sober, selling palm leaf crosses, and just minding his business. But with a felony drug case and serious mental health diagnoses, the court isn't buying easy excuses. She gives him a brutal choice: 4 years in prison with no probation, or inpatient drug treatment and strict supervision, knowing he could still end up back here. If you were in his place, which path would you take? Comment below, and don't forget to like and subscribe for more courtroom breakdowns.
Jason
Defense.
Wolf for defense.
And are you Mr. Rodriguez?
Yes, sir.
All right, defense. Mr. Allen did come to the court, and I believe it was on Friday state. And the reason why he came to the court is because a different judge had signed on a motion to set bond. Is that correct?
I believe so, Judge.
And the defense thought it was in that court, but actually the case wasn't in that court. So have you all come to an agreement?
We have, Judge, Mr. Edelman, I believe, has agreed to a $10,000 bond. I have the motion prepared and I made those changes. I am prepared to walk him over to satellite, Judge. We are going to be making a bond for him.
All right, Mr. Rodriguez, you want to raise your hand for me? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand, state your name for the record.
Jacob Rodriguez.
All right. Mr. Rodriguez, have you ever been diagnosed with any mental health issues? Have you ever used any type of drugs in the past?
I have.
No marijuana, nothing.
Oh, yes.
And if you're given bond, do you have a place to stay?
Yes, sir.
And it's the court's understanding that you all have agreed to a bond of $10,000. Is that correct?
If that's acceptable to the court.
Yes, Your Honor.
All right. Any other requested conditions of bond?
Judge, are you working? Yes. I would imagine that the court will want to keep track of him, and if he does have GPS, we would just ask for work release. Of course, he would provide that to his
Is
pre-trial
he
officer.
currently on GPS?
I don't believe that he is, but if that becomes a setting, I would just want to be hopeful that he would be allowed work release.
All right, no, I just want to know, so the only case that the court sees is this case, which is a drug case, and it's a third-degree felony. Is there anything else?
Only those cases that are pending that was the subject of this MTR, Judge. Which I believe are a couple of 1 to 4 case.
Mhm.
There's an allegation, I believe it might be THC oil, and then a UCW as a misdemeanor. Judge.
May I, Your Honor?
Yes.
For Jacob Rodriguez, possession marijuana, 4 ounces, 5 pounds, manufactured delivered controlled substance, 100, manufactured controlled substance, 2 or 2A for 400, manufactured deliver controlled substance, 2 or 2A for 400. You see that. And that's it.
All right, this is what the court is going to do. Court will follow your agreement, set your bond at $10,000. I'm going to ask for sober support meetings, 90 and 90 days.
Okay, Judge.
There's going to be partial GPS for employment only.
Thank you, Judge.
Is there anything else from either side?
Not from defense, Your Honor.
Nothing to stay, Your Honor.
All right, then Deputy Laura, we're off the record. Deputy Laura, is there anything that he needs?
I have the bond paperwork with me, Judge. I'm going to walk him straight to satellite.
All right, and then here's my question, Ms. Ferguson. I see that the warrant was recalled on this case, so I guess the other cases are out there.
Thank you, Judge,
You're
for
welcome.
your time. May we be excused?
You may want to get a copy of that.
Okay, thank you, Judge.
So I have a question then. Is there an active warrant on this case at this time?
There's an active warrant. There's an active warrant, I guess, it was filed, the MTR was filed in 2023.
Should be the MTR.
But I saw that, let me see that file again.
I'm just checking to see if the warrant's on this case then.
No, because on this case, that's what I was wondering, because law, can I have the parties announced for the record for the state
Your Harris Settlement.
defense?
Brian Kimbrough from Mr. Wardlaw.
And are you Mr. Wardlaw?
Yes,
Counsel, you received all of the discovery?
I have.
Did you review it with your clients?
I did.
Mr. Wardlaw, did you review the document entitled Application for Community Supervision
Yes, ma'am.
or Deferred Adjudication? Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
Yes.
Mr. Wardlaw, did you review the document entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes.
Did you understand you're charged with possession of a controlled substance, penalty group 1, 4 to 200 grams as a second-degree felony? Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, sir.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Wardlow, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, there's a $2,000 fine. State recommends deferred adjudication. They're taking in consideration the following night mag numbers: 764, 693, 764, 694, and there's to be restitution for drug testing. Did you understand that to be the plea?
Yes.
Defense is at the plea?
Pettis.
State is at the plea.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney?
Yes.
Did you understand it?
Yes.
Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions? Outside the agreement, the state is recommending that your community supervision be for a term of 7 years. There be a TAP evaluation and 200 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence?
Take this over. Thank you, Your Honor.
No, Judge.
All right, state, you may be excused. Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney?
Yes.
Did you understand it?
Yes.
Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. To find you guilty, the court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, I would ask the court to follow the plea bargain, talk to Mr. Wardlaw, believe he can complete the probation successfully. I would ask the court to consider probating, part of the fine. He's currently not employed and he was, I believe, homeless at the time of his arrest. So he's got to get his feet on the ground. But he believes, he's told me that he's made a change. He's not going to be using controlled substances anymore. And he would like an opportunity to show the court.
All right. How often were you using?
About once a week now.
Do you have any children?
I do not have.
All right. If you were released, who would you be living with?
My sister.
Okay. Have you asked her if you can live with her?
Yes.
How far did you go in school?
I graduated high school now.
So what have you been doing with your life since graduation?
I've just been working in restaurants now.
How did you become homeless?
When I got this case, I lost my job and I thought I lost my job. I couldn't pay the rent, so I wanted to lose my pay.
So what were you doing at this location?
I was with a friend of mine. He was, we just got off work and he was gonna go pick up clothes.
They don't mention a friend in the police report. They just say, well, they do say you were in the passenger side.
Yes.
So who's your friend?
His name was Aaron Randall. He's no longer in Texas anymore.
Okay. What does your sister do?
She works at a doctor's office. I believe it's a nurse assistant.
Okay. All right, this is what the court is going to do. Court is going to sentence you to a $2,000 fine that will be probated, 6 years deferred adjudication, taking consideration night mag number 764, 693, 764, 694, restitution to SAPD for drug testing, regular reporting by Zoom or in person, no contact with Aaron Rangel. I'm going to do a referral to felony drug court. That's to be in custody. A TAP evaluation. If not accepted into felony drug court, then that TAP evaluation will be in custody. Follow all recommendations. Proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact. Aaron Randall, I thought he said ring health.
No, I'm sorry. And judge the UAE.
All right, we're gonna do the UA hotline until further notice. All right, is there anything else you need from the court to be successful? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes.
Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
All right, we can go off the record. And this court to be successful on probation, communication is key. If you have an issue, let probation know. If you feel as though they're not addressing it, then you can always come back to court. You understand?
Yes, sir.
All right, thank you.
Thank you very much.
All right, everyone, we're going to take our break. All right, you can have a seat. And all right, so in this case, this is where the court is with the cases being transcribed, or at least the jail calls. So the case with Mr. Guzman, that translation has been completed. And then they're going to start on the next one, and I believe it's your clients that will be next. This is what the court is going to do. They have a USB drive for Mr. Guzman. They're going to put it in my office. I am going to make a copy of it and give it to his attorney only. And I'm going to review it to see if there's anything there. And then if I determine that there is nothing there, then the only person who will have that USB will be his attorney.
Understood.
All right. Now, I know there are certain issues of whether or not someone who is passing themselves off as an attorney, whether or not that's privileged or not. So I'm reviewing that. If there's some case law you all wish to present to me, you can. However, I will tell you, if the defense wants to present something, or if it appears to me from reviewing the interactions through jail calls and jail videos with the person pretending to be an attorney, if it appears to the court that that person was presenting himself as an attorney, and if it appears that the defendant thought that person was an attorney, I don't think ethically it would be fair to breach that just because the person is not legally an attorney. I think that would be not fitting with the spirit of the rules. But if someone has any of the information for the court that they deem my interpretation of that is incorrect, let me know.
I agree with that approach, Your Honor, and I'm assuming that the procedure that you're saying you followed with Mr. Guzman and intend to follow, that would be the same roadmap for how you're going to do with, how you're going to deal with my client's statements as well. And I am in agreement with that.
Yes, that's how I intend to proceed. Now, there's a second issue, and you may want to confer with the state with that. My understanding is that the state, I don't know if they have filed charges against the person or not, but of course, in order to prove that case, they may need that information for that case. And if that information is going to be used for that case, then we'll cross that bridge when we come to it, or whether or not it's discoverable, or they should have it to prove another case against someone other than your client. My only concern is if it's something that is incriminating, of course, there would be an issue of you're not using it for trial against either of the defendants in this case. It's just very complicated. And so we'll cross bridges when they're built. So I don't know how long it's going to take to transcribe for your client, but it does take a while. So I'm going to reset this for November. And if we have all of the translations by that time, great. If we don't, we'll see where we are. I just don't think it's fair for anyone to proceed without the transcripts.
Agreed.
All right, Ms. Ferguson, can you give me a November setting on this case? And state, you're not intending to try these cases together, are you? All right, so then we may be able to start proceeding with Mr. Guzman.
I think it's November 14th.
All right, we'll come.
Judge, I was just looking at my calendar. I was gonna say the only week that probably is gonna be a rough one for me is that week because I have a trial scheduled in Comal County that I believe will likely go.
All right, Norma, can we put it the week of November 4th?
Yes,
Could we do it on the 7th?
yes, sir.
Perfect.
All right, is there anything else?
No, Your Honor, thank you.
All right, Mr. Lopez, do you have any questions?
Stephen Carmona is on 6 years of deferred probation for repeatedly violating a court order, and now he's back because he drank and ignored the judge's command to attend daily sober meetings. He talks about long work hours and caring for his 5-year-old, but the judge keeps coming back to one thing. You had months to speak up and fix this, and you waited until now. If you were in her chair, would you keep him on probation or send him to prison? Comment below, and don't forget to like and subscribe for more courtroom breakdowns.